Okay. Can you guys see that?
Yes.
Okay. Okay, Amy, you can start recording.
Already did.
Okay. All right. What we're going to talk about today is listings and what you have to have. These are the documents for command, as we talked about, need to be in command. This is for the compliance side, but these are the documents that you put together when you put a listing together. So you do an E&O from the title company, owner encumbrance, one to find out if they are the owners that actually said they are the owners, and what's against that property. No surprises. So is there an IRS lien? Is there a mechanics lien? What kind of liens are against this property? Okay. A seller net sheet, which you can get from the title company. They have apps to do that, or they'll do one for you. Public records are the realist tax, which says, here's Jane Doe, they own XYZ, 123 Main Street, and there are 3 pages. When you go into realist, you have to click realist, and then you put in the address of the property and go to the right side and hit report. Once it pops up, then click only on the one you need, unclick everybody else and just click on the one you need. Go to the right side, it says reports. And that will bring up the 3-page. Okay, that'll bring it up a 3-page. Hi, Kathy.
Yeah.
Hi, Kathy.
Hi, Donna.
Hi.
Hello.
This is the list that you have to have when you're putting things into command and when you're going to take a listing. Okay.
Okay.
O&E and net sheet. Public records are realist. And you want to put in, hang on, let's get, hi, Haley. Let's get her connected. Hi, Haley.
Hi, how are you?
Good. Okay. So this is starting with the list that you need when you take a listing. E&O, owner encumbrance, a net sheet, public records. You go to Realist in RE Colorado, click on that, put the address in. It'll pop up, find which address you want, click on it, go to the right side. There's reports, click on that, and it's a 3-page report. At the top, it's going to have the address, the name of the seller, the address, legal description, etc. In between has tax information. At the bottom, it has the loan. So you've got to understand what that loan is against the property. You want to, you're going to have a listing agreement, definition of working relationship, seller advisory. The other thing that's not on here that you have to have until we get through COVID, which maybe by the end of the month, I'll have that go away. Seller advisory, COVID-19 advisory. Seller's property disclosure, square foot. Common interest community checklist is used if there's an HOA. Closing instructions, source of water, a MLS printout sheet after you've got it up and running in the MLS, you have to put that in. Lead-based paint obligation and disclosure if needed, if it's the lead-based paint time frame, and a seller's authorization and short sale if that is what you're working with, and any and all extensions. Once
Hey,
that,
Donna.
yes, ma'am.
Sorry, I had a question.
Sure.
For the source of water, when I was doing the contracts for that other place, I happen to know what their source of water was, but where would you find it between real?
You have to ask the seller.
Okay. That's good to know I wasn't missing anything, because I was like, it's not listed anywhere.
No, if it's where you guys have a well, you've got a well permit number, okay? And that's what you put in. If you're like here in Highlands Ranch, we're community water, and you have to put the community water information on there, but you're on your, in my world, it is the Metro District water bill that comes. So you can find out from the seller what that is. A lot of times it's Denver. Sometimes it could be Parker water. Oops. Could be Parker water or whatever. Just always ask the seller. Okay.
Okay.
Good question though. Any and all amend extends. Now, when the house goes under contract, you have to put it in the under contract in the MLS. You have a contract that the seller and the buyer have negotiated. If there's a counter, you put a counter in. Earnest money and receipt, you put that in. You have inspection, objection, and resolution. Again, lead-based paint, disclosure sales if needed. A lender letter if they have one. This is when they sign all of the seller's property disclosure, square foot, source of water, closing instructions, mend extends, and post-closing if needed. Go to command to do commission request. That's after you've uploaded everything. You get, when you upload, the documents you upload to me after it goes under contract is after you have inspection, objection already resolved. Then you can upload everything and then submit it to me to review. Then go to command. There's another little thing up there that says commission request and fill that out. If you have any questions, email either Amy or RMCA, okay? When you close, ask don't
I was
have
gonna
the,
ask.
yes,
Sorry, Donna, can you hear me?
yes. Who asked the question?
On timeline, is there a printout? Yeah, where I'm at.
Haley, you're asking for a timeline?
Yes.
Okay. What happens is this first part up here are the documents and that you have to have. Make sure you have all of those within the first 48 hours or 72, okay?
Okay.
When it goes under contract, you don't give me, that's when you upload everything into command. Under contract, do not give me any documents for me to review until after your inspection, objection, and resolution date. Okay, that's in your buy-sell contract. Does that make sense to you, Haley? Okay, then
Yes, yes.
closing, the title company is going to say, do you physically want documents or do you want an email? Go ahead and get an email to you, then you can upload the documents. And there are 3 categories. You've got title information, you have closing, a copy of check or distribution, and a copy of the under contract MLS. When you have a new build, you won't have the MLS, but you will have all the other documents when you close. Okay. So this is a listing agreement. You always check seller's agent. You put the date you're putting it together. And then you always check 2.1 is a multiple person office. You go down here and from your realist, you put in the seller's legal name. You've got, that's going to be automatically put together either in DocuSign or CTME. So the brokerage firm name and your name. Then it's the county, which you get off realist, legal description, address. Please check and make sure that's properly done. Now you go down to 3.7, and this is the beginning and the end of your listing agreement. I would make your listing 6 months, because if you have to have, if one offer comes in, it's accepted, they go through the inspection and it falls apart, or it goes through the appraisal and falls apart, you want to have enough time to get back in there, okay? So 6 months is a better time frame, even though the seller's going to say, well, they sell in a day. Well, yeah, but it might not stick. We have a lot of properties that fall out. On 3.9.2, it's if there's a holiday or something of that nature, you will extend it to will or will not extend it, whatever your preferences, I'm fine with. All right, number 4 is your broker relationship. It tells you different things. You're a seller's agent, really? Okay, that's what you do. You don't have anything other than that. That's the box you check down here. You solely represent the seller. You do not have, if you have a buyer who's your buyer, you have to ask permission and get a change of status document signed. I would try not to do that if possible. I would treat them as a customer if they call off your sign. If they're a buyer that you already have, then you have to ask permission to change status. Then on number 5, hang on just a guys, I've been talking since 9 this morning, so. Mary knows it gets a little hard here. These are your duties, okay? You cannot change any of these duties. You have to understand them. You don't have to memorize them, just have to know, understand what they are. And then 5.8 is you will disclose who the buyer is and who the co-oping broker is. That's okay. Now, if you're going to get fired, you're going to get fired on paragraph 6.1, 2, and 3. 1 is promoting the interest of the seller. 2 is seeking the price and terms that are set forth in the listing agreement. And 3 is counseling the sellers to do certain things. There was a seller who screamed at me about 2 months ago that they wanted to get out of their listing agreement. And I said, no. She says, well, he didn't do his job. I said, what part of his job did he not do when he brought you 7 offers? You chose one. Just because it happened to be the wrong one does not mean you get to blame the agent. So either you get a new agent or you stay with the one you got. So I'm not doing, just because there's a whim, I will not release them because I'm the ultimate person that gets to release them. So now you're going to have your selling commission. So the lowest you can go is 5.8. 2.8 for you, 2.8 for a buyer's agent or a transaction broker. I would prefer that you try to get a 6 or more if possible when you do this, because if you have 6 $1 bills and you lay the $6 bills out, 3 of them automatically goes away. One goes to your taxes. 1 goes to Keller Williams. 2 go to Keller Williams, and 2 stay with you. One of the dollar bills goes for taxes, and that leaves you with $1 bill. Because when you say in that spot you get 6 or 7%, they think you get it all, but you need to explain to them where it goes. Okay. I always put a lease in here, not that I'm in the leasing business, it just keeps all parties honest, okay? Then on 7.1.3 is other compensations, which right now there are none. The holdover period on 7.2.3 is 120 days, and you want to put that in here so that you know that if you've handed over a list to a seller of the people you showed the property to, if they come back and buy, they will owe you a commission, okay? So now we go down to paragraph 9. This is a real important one. Yes, I will be submitting to more than one MLS and will put into other information to exchange. Sellers authorize that use of electronic and other marketing material, except none. Okay, then you're putting it into more than one internet and displaying the address and the listing. Then on 9.2, I would encourage you to go to, if most of you belong to Smedra, get an electronic lockbox, guys. It's very safe. There's lots of things and benefits for it. Century Lock is our electronic lockbox. It's $100 a year. It's not that expensive. And it's for a safety reason on your sellers. I always put other instructions as must call the seller for showings. This way it is to make sure that the seller knows who's coming into their house. And they don't want to come home or a child come home and not know that they don't have a showing, okay? Now on 9.2.3, this is important that you put in active licensed real estate broker and a licensed appraiser. No unlicensed person can come in. So we have a lot of lazy agents. I don't know if you've noticed that or not, but that don't show up for their closing. Mary's laughing about something that happened this morning. But they don't show up for their inspections and let the people in. They let anybody do it, unlock the lockbox, and no, that's not acceptable to a seller. You want to make sure who's going into the property. You want to know who it is, and they have to get it come through you or your TC to get this accomplished. But you really, really must know they have to be licensed. So when somebody pushes back and says, hey, my unlicensed assistant is going to let them in, no, the seller in the listing agreement is required that has to be licensed. and you will get pushback on this. On 9.3.1, I always put this statement in so you're not locked into certain things. All professional marketing services offered by the brokerage firm as broker deems necessary. The key is that if you have a 1,000 square foot condo, you can't take 45 pictures as you can for a 6,000 square foot house. So you want to be sure that you offer what is acceptable here and not lock yourself into something you don't really can't do. So you're going to get pictures and you're going to put it up on the MLS, but you're not going to have 45. You're probably only going to have 10 on a 1,000 square foot condo. So, and you're not going to do certain things that you would for a bigger house. So that's a good statement in general. So on 9.3.2, they authorize the video taping from the interior and exterior. Now, this is where somebody could say, I don't want my child's room videoed. It's great for the backyard, but don't video anything about my child's room, okay? And that's where you want to put that. Then you want to go down to 10.3, which says there's no existing listing agreement. And now somebody could call you and say, hey, I've got my house listed, but I want to fire my agent. You can go over and give them a listing agreement, but before you have them sign anything, you make sure you have a copy of a statement or of the document saying when their listing agreement expires. Then you have the Colorado Foreclosure Act on here. It's just here. You're going to run into this paragraph a bit more towards the end of the year. So you might want to read it. You don't have to learn it. You just have to be generally aware of it. 11.1 is where you put the price. 2 is where you put the terms. And you have to make sure that the price you're dealing with will accept cash, conventional, FHA, and VA. If you go above, I think it is 597, you can't do conventional or FHA. It has to go into only cash or conventional. So you have to be sure you know what those ceilings are, and Patrick does know what that is, or even Henry Russell.
Hey, Donna, can you say that again? If it goes above what? You can.
I think the price, the ceiling that a VA or FHA can get nowadays, I think it's 597, and it depends on the county that they're in. It's something to check with Henry or with Patrick. I don't know what the counties are. There are different ones in the county, but if you get real high, you start. Just the rule of thumb: if you're over 600, you're not going to go FHA or VA. 11.3 is discount points. At this type of market we're in, we don't have any at this time. 11.4 is if you are going to offer FHA, there's a price that the seller has to pay because the buyers can't. So you want to put a ceiling on there. And then you want to say seller shall decide at the time of offer if there any seller concessions are to be given. You don't want to box a seller into something if he or she does not want to do something. Then you decide on how many dollars that you have for your earnest money. Don't make it really heavy, but you want to make it painful. So if you've got a house that's $350, it could be $3,000 to $5,000. If you go higher, you want to make it $5,000. When you go over $7,500, you're in a different court if there's a dispute. When you go to $1 million, it usually is anywhere from $30,000 to maybe $100,000 as a deposit, depending on the price. So just be aware that they have, if there's a dispute and they don't go, when they go to mediation, don't like it, they could go to court to sue. That goes to the district courts, and that's a much more expensive court. Seller, how they're going to get the proceeds. You can check the cashier's check. I think you need to check with your title company, find out, are they going to wire instructions to the seller's bank? And the seller and the closer must talk. You cannot put anything in an email regarding wiring instructions, period. That has to be between the seller and the closing company, okay? FERPA is the Foreign National Act. And if you the question you want to ask your seller, On 11.7 is, are you a United States citizen? If they're not, the FERPA Act might come into play. So you must notify your title company about that. On 11.8 is if you've lived, do you live half your year here in Colorado and in the other half in Arizona, which a lot of people do. There could be a 2% Colorado withholding tax at closing. Now, 13 is dealing with inclusions and exclusions, which is pretty standard until you get to the garage door openers. Be specific. Is there a 1 door, 2 doors, 3 doors, 4 doors, whatever it is? Put the remotes the same. Then if you don't have any of the solar or water softener or security or satellite, check the box none. If you've got one of those, then check the box, okay? In exclusions, you put that are not attached. This is just telling you here. Then your personal property is that there's no encumbrances at the end of the word is except, and put the word none here. Then on 13.1.4, other inclusions, kitchen, refrigerator, freestanding gas stove, microwave on counter, all located in the kitchen. Be specific where these exclusions are or where the inclusions are, okay? Now you go down here and you want to lease, there's none. Now you're going down to what's going to be excluded. Your washer and dryer located in the laundry room on the main floor, in the basement, upstairs, wherever it is, or the 2 washers and dryers located wherever. These are, be specific. The more specific you are, the less opportunities for having to buy some of these appliances. Your trade fixtures on 13.3 is none. These are just usually none. Now I have you fill out 13.4, even though I know that it's a 3-car attached garage. Now the reason I have you do that is that if you're listing a condo or a townhome, this will trigger a thought to say, hi, Mr. Seller, do you have a reserved parking spot in the basement or outside? Are the attached garage, are they detached? And what would the number be? So it'll trigger conversations for you. And then if any, do you have a storage area? Do you have a storage closet or something that conveys with the property? So now water rights. Rarely are water rights conveyed. Every once in a while, water and mineral rights will. If you're out where Tamara is on this one, you have to check the box, and there's a well permit here. Every well in the state of Colorado, with some very rare exceptions, are recorded, and you have a well permit. Make sure that permit matches the person who owns the property, because we've already had somebody in the last year where the permit did not match. The permit was not the right permit to go with that property. And the listing agent never checked it. So it was a huge problem. So be sure you check it. Then on 14 are your entitled encumbrances. You always check special warranty deed right here. These warrants are not what they used to be. So that's what you do. 14.4 at the bottom of your real estate information is where your first deed of trust is, and approximately blah, blah, blah. Whatever was recorded at the time they purchased the house, or if they've refied, depending on how many years are involved, there's really not a lot of things that go on. So you can put the original or take a few thousand off, but put it in here, okay? It reminds you to tell the title company, hey, we have a loan, we got to get a payoff. As they see this, some title companies want it, sometimes people don't, but it helps you. No, there are no leases on 14.5. Now 16 is dealing with HOA. So you want to get information from the seller about, where the HOA is, how much it is it paid monthly, quarterly, or yearly? In my world, I pay one monthly and I pay one quarterly. Is there more than one? You want to be specific so that you know you've got the right amount of dollars in the MLS. Now on 17, we want to say upon mutual agreement, because we don't know what that contract's going to say. We want it to be fair to both parties, preferably your seller, because that's who you represent. You also must say, excuse me, you have to disclose any defects. And I would encourage you to have all sellers put in a seller's property disclosure to the best, fill it out to the best of their knowledge. That document is what they fill out, not the agent, okay? If there's something different, you need to know, but they can't hide material facts or defects. It's going to be found on an inspection. Now, if the property is a lead-based paint age, which means January 1st to 1978, then this is when they're going to have situations where the you want to put this in and fill it out to the best of the seller's knowledge, which most of them don't have. Now, on the next one, 18.2.3 is carbon monoxide alarms. This you have to have before the property is listed. It must be there. It is 15 feet from all the sleeping areas. You have to have one. So you've got to be sure that these up. If you have an FHA loan, a buyer becomes an FHA or VA loan, and these carbon monoxide detectors are not in, the appraiser will walk out and they will charge the buyer another $150 to go back and finish the appraisal because the carbon monoxide detectors were not there. So it's vitally important that you remember that you have to do this. So there's a battle, or was last week, on 18.2.4. The property will be conveyed in the condition existing as of the date of the contract. Well, the seller really didn't get all the crap out and all of it hit the fan. It was a big mess. Try to impress upon the seller that when you accept a contract, and you must get out all of the your property and clean up all the trash before the date of closing, or if you're doing a post-closing, before you give the keys to the buyer. It's really imperative. Now, on 19, the seller has a right to cancel and the buyer has a right to cancel. I'm the final word on whether the property, whether the office will retain the listing agreement or not. If the buyer forfeits their earnest money, 20 says 100% paid to the seller or divided between you and the brokerage firm. I never check the other one. I always give it back to the seller because they're the ones that have gone through a lot of pain and agony here. So we want to maintain the property, non-discrimination. You can seek legal counsel. You can, if there is a dispute, you have to go to mediation. It has to be done relatively quick. Then on 28 is telling you what is going to be attached. This is general information on 28, additional provisions. This is where I list my transaction coordinator and put her number in, her email address, and who's going to pay for it, okay? Then on 29, it's what's going to be attached to this listing agreement. We're going to have a seller's property disclosure. We're going to have square foot. We're going to have a seller's advisory, and also at this time, a seller's co-vet advisory 19. Common interest community checklist for brokerage firm if there's an HOA, closing instructions, and seller's proceeds sheet. There's a spot for them to sign, and lead-based paint if it applies. Don't put this wording in here, lead-based paint, obligation seller, if it does not apply. Then 30 down all the way to 35 is pretty self-explanatory. Now, who's got a question? Everybody is like, you're drinking from the fire hose, aren't you? It's okay. It's all right. What I would like for you to do is I want you to write a listing agreement. I want you to use your own house, a friend's house, a condo, whatever. I want you to go into Realist, get the right documentation and information, and write out a listing agreement. That way you know where to go, you know where the spots are, keep it as your sample, okay? Now, along with this listing agreement are definitions of working relationship. This tells and explains to a seller what kind of representation can be given. You are a seller's agent. You represent them totally, okay? If somebody wants to buy the house and calls off the sign, you want to treat them as a customer because your fiduciary duty is to your seller. So now let's go down here. This is seller advisory. This is a document that was prepared by our in-house attorney. So he's giving you all kinds of information. Please read and see what it says. Valuables are to be put away and stored. Earnest money disputes. What happens when a buyer possession prior to closing, buyer possession after closing, what happens? Solar panel leases, wire fraud, all of this stuff is spelled out. What's a home warranty? How does that work? HOA rules and what happens? Seller financing, homeowners insurance. All of these things are things that you have to look at and make sure your seller understands. There also could be some cost because the buyer's getting his inspection. He may say your furnace is bad. You're going to have to pay to have somebody come out and certify your furnace. There's all kinds of things. The seller needs to be aware. If we don't prepare them, they're going to be very unhappy campers, okay? Now, our next document is a square footage disclosure. This is what you get off of your public records. You put it in this manner. Make sure all of this is not got NAs in there because you can take them out at the bottom. It says, click the dot that says remove NAs and take them out. This is what you've got. You sign it, the seller signs it, and the buyer signs it, okay? Source of water. I know in the seller's property disclosure, I think it's under H or J, that a lot of agents just put it in, but they don't put in very much information. I ask you to get a separate document, and on this there's a blank line. What goes in there when you get an offer and it becomes a contract, you put the contract date in here, and then you make sure you've got all of this information filled out. If it's a well, you put the well permit up here, okay? And you don't have any of these other two. You check number 1. Then on the seller signs it and the buyer signs it. This is the seller's property disclosure. This is a document that the seller fills out for the buyer, and you do it to the best of your knowledge. So what I'm telling you is you fill it out if there's something, if it's a new roof or you replace the furnace or any of those things. And G is where they have water information. It is really not very explanatory, and it's not a lot of information here. It's on H. So I have a separate document because when you list something, I want to be sure that if a buyer's coming in from an area that water is important, they have a separate document and they can't come back to you later and say, I didn't see that in the seller's property disclosure. Because if you did a poll, I will tell you that about 85% of the people don't look at this document very closely, and they don't even know where the water source is. So a separate document is needed. Now, if you're the selling agent, not all companies require it, and you may or may not get it. I would draw it to your buyer's attention if you don't get a separate document. Here's where your water source is in the seller's property disclosure. And take the seller's property disclosure with you when you do your inspection. So this is all filled out by the seller, and they sign and buyer sign. Buyers only sign its acknowledgement. It is not that they're agreeing with what it says. They're acknowledging that they received it. Okay, closing instructions. If this is what you fill out, whoever your title company is, you want to, this is your address of your property. When your offer becomes a contract, you put the contract date in here. Then you've got is going through, you agrees that it'll be coming through this the title company on both of these. The copies are going to be furnished with exceptions here. Now the rest of this is pretty self-explanatory. They're going to do a bill of sale, etc., closing statements and things. When you talk to your title company, ask them what they charge to close the real estate and the loan side. It could be $350, it could be $450, it could be $500. I don't know. They're all over the ballpark. Put it in here. Have a conversation. Then you want to ask your seller, how do you want your funds, either by check or wired? Again, if it's wired, your sellers have to call the title company directly to give them wiring instructions a couple of days prior to closing. and they go through different things here. And there's not a whole lot that goes in here after this. It's self-explanatory. Talk about for additional provisions. Most of the time there isn't anything, but it could be if it's a personal representative signing on behalf of an estate, that would be the information. You're going to have to give the information to the title company. If there's a death involved, you're going to have to say additional provisions providing to the title company a death certificate. In my case, we filed the death certificate of my husband, and it reverted because we had joint tenants in common, or excuse me, joint tenants, and it reverted to me. But if there's something odd, you put it in here. And now you want to know who's your closer and what the address of the title company is and the email address of your closer. Side note, you do not sign the closing instructions from a title company. You call 2 days prior to closing, make sure they have a copy of the fully executed closing instructions, because we will not be signing closing instructions from the title company at closing. This is vital that you do this, because otherwise they'll start arguing with you that you have to have it, and you do not. Even though their document is put together by the commission and the title companies, this is the document. Everybody has already signed it. You do not need to sign it a second time. The next document is called lead-based paint obligation of seller. This is general knowledge for the seller about lead-based paint information. So you want them to read this if the house is a lead-based paint disclosure house. Then they sign. Then the next document they fill out is, do they have any knowledge? If they don't, any reports, then check no. Then the buyers will come through and decide they may or may not do a lead-based paint. They can't destroy the house. They have to put it back to its original condition. Some people, I've only had 1 or 2 that's ever done it, but it's important to people. So it could be important to that buyer. So they sign it. Everybody signs, buyers, sellers, listing agent, and selling agent. If you do not sign, and this is not fully put everybody's signature on it, 1, it's a $16,000 fine if you get an audit and it's not done properly. And 2, if you don't get this to a buyer in a timely fashion, not just the day before closing, you want to, within the 2 to 3 days after you've had an offer accepted, you want it to be, now it's a contract, you want 2 to 3 days that you give it to them and they get it back to you. You don't want it to be hanging out there forever. This is called a seller's net sheet. You can do this on CTME if you know what all these charges are. Otherwise, go through the title company, have them do it, or do it on their app. These are charges that could be on a final settlement. If you tell a seller they're going to get $340,000 for the house, they mentally believe that's what they're going to get. But now they have to pay off their first. They have to pay closing fees or real estate fees. You've got home warranty possibly. You've got to release the deed. You have to curry it. You've got taxes from the day for January 1 to the day before closing. You could have a transfer fee on HOA. They will collect a month's fee in advance possibly, and any seller concessions. Okay, something has to be repaired or whatever. It doesn't mean it's this high a number. It just means it could be. So if you gave them the worst case scenario, they're going to clear $108,000. But you always want to do this on a listing so a seller knows how much money they're going to pocket. Now the question here is, Mr. Seller, do you have a first lien? Yes. Do you have a second lien? No. Well, when you run your information on realist at the bottom, you'll see that there could be a HELOC on it. So that would be a second loan. It's like a loan. May not have any balance on it, but you need to put it in there anyway to make sure that you ask the question. So these are important. Then you have them sign this and data. The next thing is if you get an offer, you redo your seller's proceeds sheet to what the offer is and what their bottom line. Now you can compare to what you said versus what the offer came in at, and how close are you? Or how much more did they get than you thought they were going to get in our marketplace today? in a normal market, I would do a proceed sheet. Sellers, I got it to the point, I got them $300 to $500, whatever I tell them their net sheet would be. I am that good at it. You can be that good at it too. But the bottom line is you put as much information in here as you can. You sign them. I had one house that had 25 of these because we had to keep reducing the list price. The seller, we finally got an offer. It took us, I don't know, 7-8 months to get it. We finally got it, and the seller had to bring $25,000 to the closing table. So he had to be sure to know he had to bring $25,000 to the closing table to get out from underneath this. Does he have it? I don't know, but he had to know that that's what he was bringing before he signed the offer. So this is really important to you, to the sellers. Before they sign the offer, they must know what they're going to approximate the bottom line will be. This is called the Common Interest Community Checklist for the brokerage firm. This is something that the sellers fill out. It's not going to be signed by anybody, but it gives them information. So if there's one HOA or two, you know that this is the document that has to be put together. This is a buyer acknowledgement document. This is in case somebody chooses not to have an inspection or buy a home warranty. Or if they're doing it, then put down who's doing it and any home warranties of that type. But if, let's assume they're not going to do it, you check the box, the buyer has decided against having an inspection. The buyer has decided against purchasing, check these boxes. And then if somebody says, well, why didn't you let me have an inspection? You've got a document saying, hey, you signed off, you didn't want it. This will keep you out of a lot of lawsuits. And it is in your CTM and DocuSign documents. This is telling you about a septic use permit. Tamara lives in an area that there are 5-acre lots. They have well and septic. So seller selling a property has to have a septic use permit that's updated before they sell the property, which means their septic tank will be pumped and certified and all of that. Now, in your contract that you get, it should state who's going to pay for this. Normally it's the seller, but sometimes it isn't. So if you're writing it, you want it to be the seller and make sure you make that very explicit. If you're receiving it and nobody said anything, you can also say the buyer is going to pay for the septic use permit. This is a E&O policy in your personal transaction. If you're going to sell your property, you have to use the following 4 things. A seller's property disclosure, you have to put a home warranty on it, you have to have, the buyer has to have a home inspection, and you must use the Colorado State approved form. Your E&O insurance, in order to keep intact, those 4 things have to be in place. All right, now, the deductible on your E&O insurance is $2,500 right here. This means that if you have to go and negotiate on an E&O claim, the most you're going to pay is $2,500. If you haven't got these things done on your personal or on the property itself, could be some problems. E&O may not cover your personal property if you don't follow these 4 things. This is just acknowledged as well, listing well checklist. It's just a document that if you have a well, if just for general knowledge, and you can pass it on to the buyer, it's just for general information. You have the well permit number and what kind of use it's going to be and those types of things. Buyers are always needing to do their own inspection on a well to find out if it's flowing properly, is it pumping on the right amount of pump per hour. And you can also check for radon in your well. That is a test you can do on your well. Okay, who's got questions now that you're drinking from the fire hose, guys? Nobody's got questions?
I'll have questions once I do this.
Well, here's what I want you to do. Go ahead and put your listing agreement together. I am happy to review it. and we can correct it. So you have a really clean copy of your sample, and that way we can look at it. I'll tell you where to correct it. I'll be on the phone and looking at your documentation. Do that. You don't have to do all the disclosures because those aren't real hard, but you want to get the listing agreement together. That's the hardest thing. You want to go through, where do I find it in public records? How do I do a net sheet? Those are the things that are a little bit more difficult to do. An O&E is $5. Pay the $5 to make sure you've got all your information on. If you hear the words bankruptcy, or I bought this in a bankruptcy sale, or something like that, always do an E&O, because some things are not released. Even though they say they are, they're not. They'll still show up on the title. Okay. Okay. Anybody, Tamara, I'm going to kind of pick on you a little bit. How hard was it for you to write all this up on a couple of listings that you've gone on?
How hard was it?
Yeah. Was it hard for you, or you felt comfortable?
Well, I kind of just used the documents that you showed us. So I just,
That's what you're supposed to say. Yeah,
so
right.
I went through and I made sure I was putting in the stuff that you had. And then if it was something I didn't know yet, I just left it blank and made sure I told them that we needed to go through some things and make sure we verified details. And it wasn't as hard as I thought. I just made sure that I went through every single point and kind of knew what it said. I didn't just skip over stuff because it didn't have anything to fill in. I made sure I read it.
Yeah, and I think that's important. That's why I want you to do it ahead of time. And next week we'll do a buy-sell contract. And that is something you only have couple of documents that go with. And then the following week we will go over the dates and deadlines. And I do dates and deadlines separate because sometimes it's very hard to figure out what dates go where and who has to do this and all of that. But I want you to write a listing agreement. Again, I'll be happy to look at it and correct it, and then you have your own sample. We'll do the same thing with a buy-sell contract, and now you already have your sample, okay? If you have a sample and you write it up and you send it over to me, I find a lot less errors in it. Tamara writes a really good listing contract. She really does. Just a few minor tweaks we did, but other than that, because she went through and she had a copy and she has a sample, everybody's going to feel more comfortable if you do that. Okay. The other documents are easier to do, but the contract to buy and sell and the listing agreement are long documents. Okay. And so you want to know where they are and how to do it and all of that. So anybody else got another question? And if you do one.
Donna, I have a question. Sorry, I'm in my car.
Yeah, no problem. You're fine, Haley. You're fine.
Okay.
I know it's your lunch hour, so
Okay,
don't worry.
so
about it.
I know. I'm this job. It's almost over with. But anyway, so when we go and list with the seller, are we doing this all like we bring our laptop there and put everything in right there and go through line by line with them, or how does that go?
Well, there are actually 2 or 3 emails that you do. The first set of emails that you send to them is a document where they can't sign. Okay, you just email the document. That would be the listing agreement, the definitions of working relationship, seller advisory, COVID seller advisory, and I lost my train of thought. Okay, those are 4.
Okay.
That's the first email. So once they figure out that that's good and I'm going to sign it, you resend it to them and have that signed. The next email, either you or your transaction broker does, are the disclosures. So that would be seller's property disclosure, square foot disclosure, source of water, closing instructions, and seller's property disclosure and common interest community checklist if there is an HOA. That would be the disclosure ones you send on to them. Now, in between that, what I would suggest is your first one is along with the documents of what they're going to sign as a listing agreement, I would throw into that first batch your seller's your seller's net sheet. So in other words, the 5th thing you would send is the seller's net sheet at this point, okay? So that way, when you're talking and going through the agreement itself. You can do it by Zoom or online or in person on your laptop. It doesn't make any difference. Preferably send it to an email, call them and walk them through it. But the seller's net sheet will help them understand where all of this cost goes. Okay.
Right. Okay.
And you can go and call. I've got 2 title companies, Haley. I don't remember if I gave it to you, but if you send an email, I'll send it both information to you and you can talk to them. They will be more than happy to tell you how to get that net sheet, or they'll do one for you. Okay. Now,
Great.
Tam,
Okay.
I'm going to pick on you. Did you do the net sheet or did you call, lost her.
Kim?
Yeah, Kim, sorry.
I was in a crunch, so I called her. And
That's a good thing. Crunches are
more than graceful. I was just looking at a class that they offer on next Monday, on how to prepare a seller net sheet.
Mhm.
So I think I'm gonna attend that. It's free, but
Yeah.
I did have her do it.
Yeah. And the thing about, I have to tell you guys a side note. Unfortunately, 3 weeks ago, a friend of mine lost her daughter to suicide. And she, when they had their memorial, there's a whole lot of people there. And I'm sitting with another friend and my daughter, and we're all of a sudden, Kim comes up and she goes, Donna, what are you doing here? I said, what are you doing here? Well, come to find out, Kim and my daughter and my friend's middle daughter all went to school together. And I had no idea that Kim was my daughter's age. And how often are you going to say, well, what high school did you go to and where did you go? You don't even think about it. But she goes, my daughter's standing next to her. And when she says, Donna, what are you doing here? My daughter says, well, that's my mom. Donna Evins is your mom? So, it was so funny in a sad situation, but we had a funny laugh. So it was all good. It was all good. So
Small world.
I couldn't believe how small this was all of a sudden, but it is what it is. So we got through it. But again, and if you do this and you want me to look at them, go ahead and make your samples. Just call me or text me. I do not always see the phone. Sometimes I get, like today, somebody's already been ringing at me, but I can't answer them because I'm teaching. So don't hesitate to let me know that you got it, and we'll be happy to go over it with you, okay? Everybody
Great. Thank you.
Everybody set for the day? All right.
I think so.
And I will see you next Monday for buy sell contracts. Bye, everybody.
Thank
Bye.
you. Bye.
Thanks.
Bye.